Contracts require three things: offer, acceptance, and consideration. I'm Professor Seth Orenberg, and I'm here to talk to you today about understanding when a contract is valid because an offer is made. Let's begin with some key terminology regarding offers. The person manifesting the offer, making the offer, is known as the promisor or the offeror. The person receiving the invitation, receiving the offer, is the offeree or the promisee. Since offers are usually a proposal for an exchange of promises, we can analyze whether something is an offer based on whether the promisor proposes a promise that could be enforced in law. There are two elements required for a promise to be enforceable as a binding contract. One, the manifestation of intention, and two, reasonably certain terms. Let's address manifestation of intention first. Manifestation is a reasonable, objective interpretation of actual words and actions based on externally verifiable phenomenon. This is not undisclosed information. This is not private information, and most of all, a manifestation is not a secret intention. A manifestation is an outward, objective statement or action, the reasonable interpretation of which will be judged by the perspective of who receives that manifestation. An offer is the manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent is invited to that bargain and the assent will conclude that bargain. Courts look to the outward expression, the communication of a person as manifesting intention. This is the objective theory of contract law. Courts do not look to a person's secret and unexpressed intent. A person's secret and unexpressed intent is immaterial unless the reasonable person hearing that manifestation actually knew of the secret intention. Generally, the subjective theory of contract law is disfavored by the courts. Again, the secret and unexpected intentions are generally not relevant to whether an offer is made. What is relevant to whether an offer is made is based on the objective standard. Let's see how the objective standard plays out in the famous case of Lucy versus Zehmer. A.H. Lucy owned the Ferguson farm, and W.O. Lucy was familiar with the farm and offered to buy it from Zehmer for $20,000 about 8 years ago. Zehmer accepted that offer, but later backed out, and it wasn't in writing, and as you know from statute of frauds, it was for a sale of land, and so it was not binding. But one night, Lucy and Zehmer were drinking whiskey when Lucy said, "I bet you wouldn't take $50,000 for that place." And Zehmer replied, "Yes, I would. You wouldn't give 50." Zehmer then wrote out a written agreement stating, "I do hereby agree to sell to W.O. Lucy the Ferguson farm for $50,000 complete." And then Zehmer rewrote it to change I to we, and he had his wife and himself sign it. His wife, by the way, was not drinking. There was an allegation that he muttered under his breath to her, "It's just a joke," but Lucy didn't hear that. Lucy arranged for an attorney to examine the title and prepared to close the deal and pay the purchase price, but Zehmer refused to transfer the title. He asserted that he never agreed or intended to sell the property. He claimed that he was joking all along. And, in fact, he had said to his wife, "This is nothing but a joke," before he signed it. Zehmer claimed he was drinking, that he was high as a Georgia pine. And the transaction was just a bunch of two doggone drunks bluffing to see who could talk the biggest and say the most. But a waitress who witnessed the whole process specified and verified they appeared to have a lengthy and detailed and serious negotiation. Lucy, of course, who wanted the transaction to close, maintained the negotiation, and the result was entirely deliberate and binding. The issue on appeal in Lucy v. Zehmer is whether Zehmer made a promise to sell the Ferguson farm to Lucy, where he outwardly expressed a serious desire to sell the farm, which he previously privately believed he was jesting and bluffing. So again, the issue is whether Zehmer made a promise to sell the Ferguson farm where he manifested an objective, serious, outward statement that he desired to sell the farm, but had a private, secret intention that he was just bluffing. Zehmer wrote and signed the agreement for the Ferguson farm and said, "We do hereby agree to sell to W.O. Lucy the Ferguson farm for $50,000 complete." That objective manifestation is an offer, regardless of his secret and unexpressed intentions. This is an offer by all reasonable objective standards. The clear meaning of delivering a signed agreement with the words, "We agree to sell," demonstrates a clear intention to be bound by that promise. Notably, the offer also contains reasonably certain terms, such as price and quantity in the item for sale. This evidence shows that Lucy was warranted in believing that the contract represented a serious business transaction and a good faith sale and purchase of the farm. In other words, Zehmer's delivery of the written purchase agreement, signed by him and by his wife, are sufficient under these circumstances to show the manifestation of intent to be bound by the terms therein. What about the other statements? Were they manifestations? Lucy said, "I bet you wouldn't take $50,000 for that place." That is at best an equivocal statement. Zehmer said, "I would too, you couldn't get 50. That's closer to an offer, but it's still an expression of doubt and is unlikely to be understood as an offer. But the writing was an offer. Let's talk about our next case, Embry. Charles R. Embry worked for Hagerty McKittrick Dry Goods Company on an annual contract. His job was to select samples for traveling salesmen, and his annual contract to do this was set to expire on December 15th. He was anxious about this expiration, especially as that date passed, and so he repeatedly asked for confirmation that he would continue his employment with the company. On December 23rd, 1903, he met with the president, McKittrick, and the two had a conversation about Embry's reemployment, where McKittrick said, "Go ahead, you're all right. Get your men out and don't let that worry you." Subsequently, Embry worked until February 15th when he was notified that his employment was terminated on March 1st. The issue is whether McKittrick made a promise to Embry for reemployment when he said, "Go ahead, you're all right. Get your men out and do not let that worry you." Embry made a demand to be employed for another year, and McKittrick responded, "Go ahead, you're all right. Get your men out and do not worry you." The Embry court found, quote, "We think that no reasonable man would construe that answer to Embry's demand that he be employed for another year otherwise than as assent to the demand." In other words, the court found this was obviously a manifestation of intent to be bound by the promise to employ Embry. Now that we understand the first element, let's look at the second element of an offer, reasonably certain terms. The terms of a contract are reasonably certain if they provide a basis for determining the existence of a breach and for giving an appropriate remedy. Even if both parties manifest an intention to be bound by a promise, that promise is not an offer if it is too ambiguous. So even if the first element is met of an intention to be bound, two parties that intended to be bound cannot be bound if the terms of their purported agreement are too uncertain. In general, under the common law, the price term is required. For goods, under the Uniform Commercial Code, quantity is the only required term. A court cannot enforce a promise if a court cannot determine what the parties intended to do. It is easiest to find reasonably certain terms in a promise where the words of that promise give an exact meaning to all of the performances that are to be rendered thereunder. However, even if the offer appears to be indefinite, courts will try to supply meaning so that parties that intended to have a contract will have an enforceable bargain. Terms can be supplied by courts from usage of trade, course of dealing, factual implication, and a reasonable understanding of the circumstances. Let's talk about our first case for the second element. John Cheever was a famous author. After his death, his widow, Mary M. Cheever, entered into discussions with Academy Chicago publishers about the possibility of publishing a collection of Mr. Cheever's work in a short story anthology. Cheever and Academy then entered into a publishing agreement. signed written agreement that was missing terms about missing many terms. It was missing terms about what would constitute the proposed book and many other terms. Although the agreement did give the Academy unilateral discretion to determine those terms, they were not specified in the agreement. The trial court supplied the missing terms, filled in the gaps in the contract, and it said that Ms. Cheever had to select 10 to 15 stories of at least 140 pages and found that the resulting contract is valid and enforceable. The issue on appeal is whether the book publication agreement contains reasonably certain terms such that it could have formed an offer. So the main issue is missing terms, but vague and uncertain terms play a role. The key missing terms here were it was missing the length and content of the book. The agreements made no reference to how long the manuscript was required to be. It did not specify number of pages or number of stories. It didn't say who was entitled to select the stories. The agreement contained many other omissions, ambiguities, unresolved essential terms, and illusory terms that the court here, on appeal, determined that this did not have reasonably certain terms such that it could constitute an offer. And that because so many of the terms were missing, it is not sensible to recognize this as a contract. And so in the case of Cheever, the court found that there was no enforceable contract because missing the price term, missing the quantity term, missing the number of pages and other specificity made it not an offer because it lacked reasonably certain terms. And in our last case, Sun, Sun Publishing agreed to buy and Remington agreed to sell 16,000 tons of paper over 16 months. They set a price for the first 4 months, but did not fix a price for the remaining 12 months, except they did say the price shall not exceed, had a limit, had a cap, shall not exceed the price charged by the Canadian Export Paper Company. After the 4 monthly shipments, Remington, the seller, disavowed the contract, and Sun, the buyer, insisted it still had an option to purchase the contract for the remaining paper at the maximum price. The issue on appeal is whether the paper sales agreement contains reasonably certain terms such that it could have formed an offer. Justice Cardozo wrote for the majority and found that no offer was made. The price term was not set, and the contract was therefore inchoate or unfinished. The parties would have to sit down and negotiate to a new contract, and so the court did not have reasonably certain terms such that they could enforce the contract. Justice Crane dissented because the parties had agreed to buy and to sell 16,000 tons of paper, capped at a certain price. According to Crane, so long as Sun, the buyer and plaintiff, wanted to buy up to 16,000 tons of paper at the capped maximum price, Remington, the seller, was obligated to sell and deliver that amount at that price. I believe that Cardozo's opinion in this case is wrong, based on his treatment of the contract as immutable by the court. By not enforcing it, he was at odds with his activist jurisprudential philosophy elsewhere. Further, this decision is contrary to Cardozo's own approval in other cases of modifying and adding to a contract, such as his famous decision of Wood v. Lucy Lady Duff Gordon, where Cardozo creates a duty of good faith to have consideration formed in an otherwise unenforceable agreement. That said, the majority opinion in Sun, written by Cardozo, found the contract did not contain reasonably certain terms where it lacked a price for the 12-month period. Now that you know offers, which are one of the 3 essential elements in all enforceable contracts, must contain both a manifestation of intention and reasonably certain terms. In Lucy, Mr. Zehmer made a manifestation of intention to sell the Ferguson farm when he wrote up a contract to that effect and had his wife sign it. Whether or not he was secretly kidding or bluffing is not important, since the manifestation of intention to be bound by a promise is evaluated objectively, from the perspective of a reasonable person to whom the offer or purported offer is made. Therefore, an offer to sell the Ferguson farm was made by Zehmer. In Embry, Mr. McKittrick made a manifestation of intention to continue employing Embry when he said, "Go ahead, you're all right," in response to Embry's demand for a renewal of his employment contract. Since the natural inference of these words is to understand that an offer of continued employment was proposed. Therefore, an offer to continue employing Embry was made by McKittrick. In Cheever, the publisher did not provide reasonably certain terms in the publication agreement, where it left out material details like length of the book, number of stories, and what satisfaction means. Therefore, the publisher did not make an offer to publish Mr. Cheever's anthology. And in Sun, the majority found there was not reasonably certain terms where there was no agreement on price. The dissent, however, found there was a clear intent for the seller to be bound to sell up to 16,000 tons of paper at a maximum price as set by the Canadian Export Paper Company. In all of these cases, the court examines whether there was objective manifestation of intention to be bound to terms that are reasonably certain enough for a court to enforce. When you evaluate whether an offer is made, analyze whether the promisor made a manifestation of intention to be bound and whether the terms of the proposed agreement are reasonably enforceable, reasonably certain and definite enough for a court to enforce that agreement. Remember, a contract requires three things: offer, acceptance, and consideration. The first step in evaluating a contract, whether a contract was formed after you've determined whether the common law or the UCC applies, is to determine whether an offer was made. An offer requires the manifestation of intention to be bound by reasonably certain terms. Once you have evaluated whether or not a court is likely to find an offer is made, you can analyze the next step, whether that offer was accepted while the promisee had the power of acceptance. Thanks. I hope that helps you analyze offers. On to the next step, acceptance.